Let's kick things off with a question that, honestly, gets right to the heart of our justice system. Can the police actually summon and question the lawyer who is defending you? Well, the Supreme Court of India recently tackled this very question, and believe me, the answer has some huge implications for everyone.
So, to get started, the Supreme Court actually opened its judgment with this very famous and, as it turns out, very misunderstood line from Shakespeare. I mean, on the surface, that sounds pretty awful for lawyers, right?
But here's the thing, and this is what's so fascinating. The court immediately pointed out the context. This line is spoken by a total henchman who's plotting a revolt. He's not some champion of the people, he's a demagogue. So what Shakespeare was really showing us with incredible insight is that getting rid of lawyers is the very first step a tyrant takes to seize power. In that light, lawyers aren't the problem, they're the guardians of our freedom.
Okay, so let's jump from a 400-year-old playwright into the modern-day, real-world case that pushed this entire issue into the nation's highest court.
It all started in Gujarat. So picture this, an advocate does his job. He gets his client bail. Seems straightforward. But then things get interesting. The police investigating the case slapped the lawyer with a summons, demanding that he show up and reveal the true details of the case. The lawyer, rightly, argued this was totally out of line, but the High Court actually sided with the police. And just like that, the stage was set for a major showdown at the Supreme Court, because this wasn't just about one lawyer anymore. This had massive implications for every single lawyer and client in the country.
At the very heart of this entire debate is a concept called advocate-client privilege. The easiest way to think about it, it's basically the legal world's version of doctor-patient confidentiality. It's this sacred trust, and it's protected by law, specifically under the Bharatiya Sakshya Adhiniyam, or BSA, that lets you tell your lawyer absolutely everything without the fear of it ever being used against you. It's what makes a real effective defense even possible. So you can imagine, with the right this fundamental on the line, the Supreme Court heard two very powerful and completely opposing arguments. Let's break down how this great debate unfolded.
On one side, you had the bar associations. They argued that summoning a client's lawyer is a direct threat to the very idea of justice. It creates what's known as a chilling effect. It makes lawyers scared to do their jobs and clients afraid to be honest. They wanted the court to create brand new, special rules to stop this from happening. Then on the other side, you had the state. Their argument was simple. No one is above the law. Creating a special set of rules just for lawyers would create an unfair, privileged class. They argued the laws we already have are perfectly fine for handling any rare cases of abuse.
The arguments were in. The entire legal profession was holding its breath. So what did the Supreme Court decide? Where did they come down on this?
Let's just put the question out there, plain and simple. Can the police call in a lawyer for no other reason than the fact that they gave legal advice or represented someone in court?
The Supreme Court's answer was an emphatic, unequivocal, one-word haymaker. No. A single word that drew a very clear line in the sand.
So here's the bottom line from the court. Summoning a lawyer for just doing their job is illegal, period. This privilege, they said, is basically an extension of your constitutional right not to incriminate yourself. Now, what's really interesting is that the court actually agreed with the state that new rules weren't needed. Why? Because the existing laws, like Section 132, are already crystal clear. The real safeguard against abuse, they said, isn't more rules. It's the power of higher courts to step in and shut down any illegal summons.
But hold on. That no wasn't a blanket no for every single situation. The court knew there could be very rare, very exceptional circumstances. So it laid out some super strict rules for when and how a lawyer could be summoned.
And this is where the court really struck a brilliant balance. First off, police can only summon a lawyer if they have actual evidence that the lawyer is personally involved in a crime, not just for giving advice. Second, the summons can't be vague. It has to spell out the exact reasons. Third, it needs to be signed off in writing by a senior police officer, not just anyone. And finally, and this is the most important part, the lawyer has the immediate right to go to a higher court and challenge the whole thing.
Okay, that makes sense for conversations, but it brings up another huge question, especially today. What about, stuff? Can the police just seize a lawyer's laptop, a device that could have confidential information about hundreds of different clients on it?
Here, the court made a really key distinction. The privilege protects your communication, but it doesn't create some kind of magical force field around physical things like documents or devices. That said, it doesn't mean it's a free-for-all for investigators either. To protect all that sensitive data, the court put some incredibly powerful safeguards in place. An investigator can't just walk in and grab a laptop. They have to get an order for it to be produced before a judge, not at the police station. The client has a right to be notified and to object. And if a search is approved, it must happen in the physical presence of the lawyer and their client. And, crucially, the judge has to make sure that any information related to other unrelated clients is protected and not exposed.
All right, the judgment made one last, really crucial clarification. And this one affects thousands of lawyers who work inside big companies. Does this powerful privilege apply to them too? On this, the court said, nope. And here's the thinking behind that. See, an external lawyer is an independent professional who can work for anyone. But an in-house counsel is a full-time, salaried employee of one company. The court found that because of that relationship, they don't have the same level of independence. Their advice is naturally tied to the company's business goals. So the court ruled that for the purpose of this specific privilege, in-house counsel aren't considered advocates, and so this powerful protection doesn't apply to them.
Ultimately, the court left everyone with this incredibly powerful message, adapting a famous line from American law. They declared that the police's power to summon is not an absolute power to destroy the relationship between a lawyer and their client, not as long as the courts are there to watch over them. And that leaves us all with this final thought to chew on. This ruling wasn't just about protecting lawyers. It was about protecting a principle that's much, much bigger. So think about it. How does making sure one private conversation stays private actually end up reinforcing the entire foundation of justice for every single one of us?